Hello, my name is Jay Bridgeball. I'm a real estate broker since 1988. I've seen the good days, the bad days, and the not so bad days. My passion is to educate consumer about all aspects in real estate. Actually, I sold over $1.75 billion in real estate. Now, that's a lot of experience. I went through many failures, many successes, and I've seen many stories that you will be amazed. Not everything looks so glamorous as it is sometimes. On Let's Talk Real Estate, we will dig deep down and I will take you step by step through every process from buying your first home to buying a multi-million dollar investment property. We will have various people on this show. Lawyers, investors, we'll have mortgage brokers, appraisals, and everyone else to assist us to take you to that point. My aim is to break it down in such easy terms that you will be able to follow. So please join me every Thursday between 1 and 2 and let's talk real estate. Hello, and let's get on the show today. Let's talk real estate. Today we will talk about all the laws that involve in real estate. We will get into many different topics from what involve in closing a transaction, all the way to how to prepare your will and estate planning as well. Stay tuned. My name is Jay Bridgeball, and we have here our guests, Manbir.
Manbir Sodhi. It's very nice to meet everybody. Thank you,
Yeah,
Jay, for having us here.
And myself, Amit, also from the Bridge team. So let's jump right into it, guys.
Yes, so Manbir, you've been doing this for a long time. I know you're a popular lawyer.
I have. I've been practicing. I'm in my 14th year. My main area of practice is real estate law. I also do some criminal defense work. I work in a firm with 4 other lawyers that we have assembled ourselves. And it's in downtown Brampton, 9 George Street North, Brampton, Unit 102. We've been there for about 2.5 years. We have the areas covered in our office from real estate, criminal, family, some immigration, and some civil litigation as well we've begun to undertake.
So you have a wealth of knowledge here, which is very, very important. Yeah. Now, when it comes to real estate, closing a transaction means we got the realtors finish their job. Yes. It goes to the lawyer. Could you take us what's the lawyer role from that point?
Absolutely. I think once realtors, as yourselves, have completed the agreement of purchase and sale, the next step in the process is for somebody to hire a lawyer, the buyer or the seller. There will always be one lawyer on each side of the transaction. In Ontario, unless you reside in a remote area such as Timmins, somewhere north in Ontario, you must have 2 lawyers. Right. You cannot have one lawyer servicing a buyer and a seller. Naturally, issues arise in transactions which can cause conflict, and in that scenario, if you had one lawyer representing a seller and a buyer, that lawyer would not know whose interest to protect, because there is a duty to protect your client's interest, and in such a case you would not be able to choose one interest over the other. So once you have selected a lawyer, whether you're a seller or a buyer, each party has a separate role. If you were a buyer's lawyer, at commencement, you want to get the agreement of purchase and sale. You want to review the agreement of purchase and sale. You want to take a look at things such as the closing date, the deposit, the title search date, the utilities clauses. In the event that it's a condominium or a townhouse condominium, you would like to see the status certificate. You'd like to make sure that the condo corporation that is running that condominium or that individual townhome complex is in good shape. By shape, I mean financially, to make sure that everything for your new home buyer is in order. And that is done essentially at the commencement. You also, always very important to look at the additional schedules that are attached to an agreement of purchase and sale. There's a Schedule A, a Schedule B, and in some instances
So
there.
a lot of complex documentation in there. But now, once these are being done, that is being reviewed, then the connection with the lawyer, what transpires?
Is as soon as the connection is made with the lawyer, we gather the information of your prospective client, and in that case, there's typically these days with all of the ways to interact with people, oftentimes you're interacting email or you're having a sit-down initial consultation meeting where you're going to go through with the client about how the transaction proceeds next. And the next step of it is to guide them into obtaining financing,
Okay.
making sure that the person has calculated all of the money and resource that they need in order to complete this transaction.
Yeah, you know, it's so important, as Amit will say many times, you know, many people don't realize the additional cost that is involved in closing.
Right.
And it's surprised to see that many realtors do not even tell their people these things, especially when come to financing. Some of them will, transaction is firm, they went out, paper gone to a lawyer, and these people have not gone to the bank.
Yeah, no financing at all, you know, and not just that, you know, we generally tell people, and you would know this, you know, try to have roughly maybe 1.5% of additionally on top of the purchase price set aside for additional costs.
Well, I think, you know, Jay is absolutely correct.
Yeah.
You, Amit, I've worked with, so I know you tell your clients to have that 1.5 to 2% extra. But I do come across many realtors who do not prepare their client for closing costs. And now, with these new land transfer tax rules and non-Canadian resident rules, there can be costs that no one even considered. Because the rules for the non-Canadian resident adding the 15% onto any purchase, if you're not a Canadian resident, is specified in such a way that you can actually be a person who's in Canada but not in Canada long enough to qualify
Right.
to be able to buy property, in which case there's a surplus tax, government tax, that is added on to your purchase price. And that is something that people are not aware of. And likewise, I think often people are unaware of purchasing a home in anywhere outside of the Toronto area does not require an additional land transfer tax, whereas purchasing a home in the Toronto area in the 416 area code requires an additional land transfer tax. So, for example, if you have a property that you have purchased for $500,000, and we use the ballpark figure of $5,000 for land transfer tax, although that might not be accurate. In the city of Toronto, you will have to pay $5,000 for the provincial land transfer tax, and then another $5,000 for the municipal.
Yeah,
Yes.
that's true, provided you're not a first-time buyer.
Right. If you are a first-time buyer, then you are entitled to a $4,000 discount on the
Right.
Provincial and a equal discount on the municipal.
So let's fast forward from here. Coming on, it's about 1 week before the buyer is about to move into their home. What transpired at that point?
Well, within a week to go, by that time, your lawyer should have, if you're on the buying side, you should have your client's mortgage paperwork and mortgage documentation together.
Yes.
You are going to then prepare their file, go over the numbers, tell the client, and the client should be ready, of course, for the ability to bring the balance of their down payment,
Right.
plus what we in the industry dub as your closing costs.
Okay.
And the closing costs is what Amit referred to as the 1.5 to 2%.
Can you shed a little bit of light just on title searches and how that takes effect? That's usually about 1 week before that. This time we're
Absolutely.
talking, but shed a little light on that for us.
Absolutely. So, as I indicated at the outset, once you go through the agreement of purchase and sale, you want to make sure that you are in compliance with the title search date. The title search will be a date specific to the agreement of purchase and sale where you as the buying party must make sure that title to the home that you are purchasing is in pristine condition. And by title, we mean we want to make sure there's no liens, or there's no tax issues, or there's no construction issues. Or sometimes you can run into problems where people are buying a home, and we had one like this. My client was the buyer, purchasing a home that had a basement apartment. The agreement of purchase and sale said that there was a basement apartment, so they were fine with the fact that it was tenanted, but it wasn't a legal basement apartment.
Right.
Once we did a zoning and compliance search on the property, we discovered that in fact there had been 2 building orders for them to take the apartment down, although the seller had not complied with the order, so the apartment still existed. Our client was happy to purchase the home on the basis that there is a basement apartment, but not realizing until we did the search that at some point the city will come and say, hey, you must take down this basement apartment. We have been here in the past.
That's what really title really meant, is really looking at the history of the property and what's there on the title of the property,
correct.
Right?
Absolutely.
So let's move on. We have 3 minutes more in this segment, and we'd like to wrap this up because after this we want to talk about what happened in a divorce situation. There, many people are not aware of that as well. So you are a seller. What are your expectations? No, I'm a seller. What are your expectations as a lawyer? What need to be done?
Well, as a seller, you're in a much better position than a buyer, just because the amount of work that is involved in selling is far less than what is involved in buying. But the things you have to be aware of is you have to be aware that you have sold the property for an amount of funds that is sufficient to discharge all of your debts. So, for example, we need to gather for the seller a mortgage statement balance. So most individuals have a mortgage on their home. Sometimes individuals have 1 or 2 mortgages on their home, or a secured line of credit, or something of this nature. And there must be a statement that we obtain from a bank that shows this is the balance, this is what is owed, and this is what is to be paid on the date of closing. You must pay out any mortgages or lines of credit that are attached to the property prior to the completion of the sale. So essentially, you are telling the buyer that once you give me your money, I will pay off these debts, and then you will have the home free of any encumbrance that you then can put on a mortgage or a line of credit, or as you wish. So once we have that documentation, we have the seller come in, the seller reviews these items, make sure all the numbers make sense.
We are all done. We are ready to go. Now it's coming up closing day. I sold the property and I bought another property. I'm really on edge, right? And I'm waiting to know what's happening. I'm waiting for the keys to go.
And in this situation, when you buy and you sell on the same day, you will be on edge because this is a very difficult day. To be able to move forward. You have to sell your home, get all of your stuff out of the house, and then you have to wait until you get your new house. So sometimes people are sitting on street corners with trucks loaded because they don't have the key for their new house. The new house key is only going to come when the bank gives us sufficient money to buy the new house.
Home.
Sometimes we recommend you take a day, a breather, and you overlap closings where you have an extra
but then
day.
you have to do a bridge financing, which is kind of costly as well. The next thing, so.
Or or somebody has to stay in a hotel or with relatives, which can often be inconvenient.
These are things happen. So let's take a break now. We are 34 seconds away from a break. I just want to tell all of you that please tune in. We will be discussing some really important issues. And next we'll talk about divorce situations, specifically what's involved, what to do, what not to do.
Separation included.
Separation also is important. I've seen
spouses versus common law spouses. That can always turn into a sticky situation.
It can be really bad. See you soon.
Think you have what it takes to bring value to the community? The TCN TV network is expanding and now accepting TV show proposals. Here's an opportunity to build celebrity status and become part of an elite group of community advocates that are focused on building, strengthening, and empowering our community in a positive way. Are you interested in embarking on a new adventure? TCN TV is searching for people interested in opportunities to change the conversation and pave an unforgettable legacy. If you feel you have something of value to offer, send a written show proposal to shows@mytcntv.com.
Are you retiring smart? Make your home's equity work for you. With your home's equity and our 30 years of experience, the Retire Smart Properties team can help you achieve the quality of life you've always wanted. Our services are 360 degrees. We'll give you advice, take care of staging and selling, and help you find the perfect home and community to transition to. It's time to enjoy the retirement lifestyle you deserve. Visit our website today to learn how you can use your home to retire comfortably. The Retire Smart Properties team, powered by RE/MAX West.
Hello everyone and welcome back. So now on this segment we're going to be talking about divorce, separation, and what you can expect going through these particular things.
It always starts out with love, and then marriage, and then marriage, and then divorce. Right? It always happened that way. I had one of my clients told me, here, I want half of everything. What do you mean half of everything? He said, I want you to saw the car in half, saw the house in half, saw the furniture in half. I want half. It belonged to me. And he was mad as hell.
Well,
I've seen that. So divorce is usually, as I said, marriage is sweet, divorce is bitter.
Absolutely.
What are some of your experiences?
Unfortunately, a lot of people have the misconception that it is half, exactly half, and that is what they look for, when that's not in fact the case.
Right.
Oftentimes, it sort of separates, but with a matrimonial home, each spouse, whether or not they're entitled to the property, is entitled to half of the equity. Half of the equity from the sale of the home will go to each spouse, but not to a common law spouse. A lot of times people think that because you've lived in a common law relationship for 2 years or 3 years, you are entitled to property. That is incorrect. You are not entitled to property in a common law relationship. The common law spouse may be entitled to other things, such as support or this, that, but not property rights, unless, of course, their name is on title to the property.
And can you explain the difference between common law? A lot of people have issues.
Simply put, very simply, a common law spouse is a person who you've lived with together in a conjugal relationship for X number of time, whereas a spouse is a married spouse that you are married to and you've had a ceremony with. That is the difference. And sometimes people will file their taxes as spouses, but they're not spouses.
So they make that common mistake themselves.
Absolutely.
On that same topic, what happens if, let's just say, obviously everyone's entitled to half of the equity, but there's other items involved, cars, maybe cars in one person's name. Obviously, I've had a similar situation that you and I have just recently dealt with for our clients. And can you explain a little bit about that?
Well, in our particular scenario, we had parties who were separating and who had originally come to terms on what they were going to do with various debts.
That make it easy.
Sometimes. Not this time. And they had, person A was going to pay this out and person B was going to pay this out. And typically debts and liabilities and assets are taken, put together, and they're then divided in half. So debt liabilities are split up and assets are split up.
So if I have my RRSP, I can't say I'll keep my RRSP away, right?
You cannot. But if you agree with your, let's suppose the spouse has RSP too, and she says, okay, Jay, you keep your RSP and I'll keep mine. Yours has 100,000 in it, mine has 900,000 in it. Then in that case you can do that, but you must agree to it in writing.
Okay, that's interesting. So in situations where both parties come to a mutual understanding, which is very, very small anyway, they can resolve it with one lawyer. Other than that, again, it requires, I guess, two lawyers.
Two lawyers, again, absolutely. And sometimes In our office, we are lucky enough, as you know, to have a family lawyer, so we are able to give people family advice. But in typical instances where you have just a real estate lawyer, you will also then need a family law lawyer.
Okay.
And the family law lawyer will be the one to guide you on specifically what you're entitled to, what your share is. And then when the sale of a transaction is happening and the sale is completing, at that moment in time is where the real estate lawyer will split proceeds and split funds, and everybody must agree.
So, Manbir, you could potentially have 4 lawyers involved in a separation or divorce.
Absolutely.
Okay.
And
could you just walk us through the process in a very short time?
Assuming everyone agrees.
No, right. You got a lawyers
yeah.
and you have everyone. Just walk us through the process.
You will have a real estate lawyer, one for the buyer, one for the seller.
Right.
Then the two parties, not buyer and seller. They're two parties that are selling.
Right.
There'll be one real estate lawyer, okay, and then each of those parties has their own family lawyer. So 3 lawyers in total.
3 lawyers total.
Okay. And those 2 family lawyers will decide how the sale proceeds are to be split. They will tell the real estate lawyer, and the real estate lawyer will divide the money that is left over from the sale in accordance to the wishes of the family lawyers who are representing each person.
Okay, but let's say I'm about to divorce. I want maybe my wife to get 40%. I take 60%. I'll give the kids about 20%. Is that something that can workable? But or because we are married, we are in holy matrimony, we cannot do that. It's obviously 50-50.
Well, unless of course you both agree to take some share less than that which you are entitled to. So for example, in your example where you're willing to give some share to the children, in that case, if both parents are agreed that, okay, instead of 50 I will take 40, instead of 50 I will take 40, leaving 20, that 20 can go to the children, then it's fine.
I have a potential situation for you. So let's just say, for example, the home is sold, closing day is done, and everyone has agreed X goes here, Y goes here, all the money is divided. On that day, somebody says, you know what, I changed my mind. I don't think this goes here or this goes there. Can this delay the situation?
Absolutely. What can happen in such a scenario is the sale can be completed, in which case the buyer has given us funds as the selling lawyer.
Right.
I've now got funds in my trust account. I am not permitted to touch them, and I will then not be permitted to split them until you now come to an agreement about who gets what. So,
but Manbir, I have bills that need to get paid. I just sold my house. I need to pay my bills.
And unfortunately, the only bills we can pay are the mortgage, the real estate commission, of course, legal fees, and that's it. And in case there could be property tax, which is also permitted to be paid. But if you have personal bills to pay, then we encourage everybody to come to some mutual understanding.
Yeah, at least you're right. That makes sense. Now let me step backward now, because it's a divorce situation. One spouse living in the home don't really want to sell the home. The other spouse already they got
realtor knocking on the door and ready to sign.
They can't even go home anymore because there's a restriction in
Right.
them,
Yeah.
right?
Right. Yeah.
Now, when you cannot get this happening, how do you proceed? Because now we got a position where husband wants to sign, willing to sign, wife is living in the home and says, you know what, I am not moving, I'm not signing anything.
Well, you then have the scenario where the person who does not wish to leave the home can buy the other person's share out. So they could, in theory, go to the bank and say, bank, give me a mortgage by myself. I will take those mortgage monies and I will pay off my spouse. Spouse gets their share and they leave.
Right.
Or you then have a court battle.
Okay.
And in a court battle, as we all know, nobody wins except the lawyers.
Well, they
So-
said it's like a cow where the husband is pulling the tail, the wife is pulling the head, and the lawyer is milking away.
Yes,
right? So that's what had to happen,
and
right?
that's exactly what will happen,
Right.
because
So-
the husband will say, I want to sell. The wife will say, no, I can't go anywhere.
Right.
And
So
this
it
is the
become
problem.
eventually a court sale where the
That's
court will order the property to be sold,
That's
and
correct.
the money sits in the trust fund until everyone decides. Right.
That's right.
Yeah, I've seen those situations before, because sometimes it's very bitter, but it
Yeah.
has to happen along the line, especially when there are children involved. When you have let's say the wife there saying, you know what, I'm with the kids, I'm in the home, and I have to get enough time. And here the other husband is out of the home already,
Right.
and he needs money. He's paying the mortgage in the meantime
Yeah.
and everything else.
Well, yeah, and courts are very reluctant to throw women and children on the street. That does not happen very often.
Right. So
So either a bank will assist in obtaining a new mortgage for that person, or they sell the house.
And qualifying also becomes an issue with that, qualifying for the mortgage on that sole income.
Absolutely.
Yeah.
Absolutely.
yeah, because you're right, the income is being split in half at that
That's
point.
right.
That
And the
could
property
create
value is
additional
going
problem.
up. So
Right.
Yeah.
What would be your best advice to our audience? They, in a divorce situation, it's best for them to just
It's
give us some
always
ideas.
in any scenario where the relationship is dissolving, it is always best to maturely come to some agreement or some understanding on how the property and or assets should be split. Once you get the involvement of lawyers to the point where and it's always smart to have the advice of a lawyer just on the issue of division, but once you get lawyers involved into the point where it's a fight, everybody loses. And it can be hard on children, and it can be hard. So the best advice is come to some rational, mature understanding.
That's usually the easiest one, where both parties says, hey, you know what, we cannot agree with each other, but
That's right.
let's sit down and let's put pens and paper,
Yeah.
let's do our own negotiation,
That's
let's
right.
take everything, and then let's go to a lawyer and get all these done.
All of these things done on a fine piece of paper.
Quickly, let's touch on separation agreement. When should that happen? Or
Well, a separation agreement, it should happen once the parties have separated prior to sale of the property.
Okay.
So that way the sale of the property is dictated by what is contained in the separation agreement. Separation agreement can include everything from paying off visas to paying children's tuition for the future years.
Right.
A to Z. It can
Okay.
it can encompass visitation, children, everything.
it's a very important legal document.
Yes.
then.
Absolutely.
Yes, we are just about stepping into our second segment. I just want to let you know that if you have any questions, feel free to call us 647-931-4701. We'll answer your question live. And please stay tuned. Our next segment, we'll talk about the importance of wills and what is involved. Thank you. See you soon.
Are you retiring smart? Make your home's equity work for you. With your home's equity and our 30 years of experience, the Retire Smart Properties team can help you achieve the quality of life you've always wanted. Our services are 360 degrees. We'll give you advice, take care of staging and selling, and help you find the perfect home and community to transition to. It's time to enjoy the retirement lifestyle you deserve. Visit our website today to learn how you can use your home to retire comfortably. The Retire Smart Properties team, powered by RE/MAX West.
Hello and welcome back. Now with Manbir Sodhi here, a very prominent lawyer in Toronto, 14 years of various experience, from real estate to, as I said, to wills, the divorce, and every aspect of it. We will be talking now about wills, the importance of having wills. Many people don't have a will, and some do have one that is very outdated or is not being done right. Mandir, what are your saying?
Well, I mean, the first part of what you said is important, that everybody should have a will. If you die or pass without a will, you will be left in the discretion of a court to decide who gets your assets or properties or anything that you've left behind.
Even if I am married?
If you are married, it still will be determined by a court. However, your spouse, according to the Succession Law Reform Act, essentially gets to the head of the line. But the order for the division will go down from a court. So your spouse may not like the way a court decides, but and that is with respect to assets and properties other than a matrimonial home.
Is that what they call probate?
Well, probate is part
later.
of it is part of the process. It is once a person has passed, the will is then being probated in order to put it into effect into an estate. But I think, Jay, your question is essentially, if you pass without a will and you have a spouse, and you are on title to your property as a joint tenant, meaning that both parties have the right of survivorship.
Yeah, join in holy matrimony.
That's correct.
You want tie the knot.
Essentially, the spouse will automatically get the property. They do not need to have a will or court process. The matrimonial home will defunct to the other spouse.
Okay, let me put this in perspective. In a matrimonial home, okay, I know I'm 50, right? My other partner is 50. Okay, let's say. But I want my 50% upon my debt to go to my kids. I don't want all that money to go to my wife.
Well,
but we are joined in holy matrimony.
If you're joined in holy matrimony, it will go to your wife.
So I don't have a say in that. We are joined in holy matrimony.
Regardless of a will. And you see, the thing is, most of our viewers don't actually know that.
If you are on title as a joint tenant, your surviving spouse will make the application to become the sole surviving spouse on title to the property, and you in that case cannot will your share.
Your share. So let's say, although we are married, let's say a bit more complicated. We are married, but I want the real estate property to be a tenant in common, where it means you have your share, I have my share. How does matrimonial law look at that? A bit more complex.
Well, if you are on title to the home you live in, even if it's a matrimonial home, but you're on title as tenants in common, which essentially for married couples will be unusual. In a tenant in common scenario, there is no right of survivorship. But then, in that scenario, the spouse's rights as a spouse, according to the Succession Law Reform Act, kick in.
So same back to square one.
Supersedes that.
Essentially, there is, but that is why you will, I have not in 14 years come across a scenario where spouses are on title as tenants in common.
That's more
to
for
a home they own.
Maybe two brothers that are renovating a
brothers,
property.
boyfriend, girlfriend, investment partners,
right?
Things of that scenario.
Yeah, we have seen many. Why I brought it up, but we have seen many situations where, as time go by in life, people say, "Hey, you know what? Yeah, we are a companion. We live most of our life together. We don't want to divorce, but you know what? I want at least some of mine to give to my other outside relative. I got a kid with another wife sometime down the road,
yeah.
and these kind of things. So we have seen these situations.
And in that type of example, you would be correct in being a tenant in common and then being able to provide your estate with the authority to give that share to anybody.
Right, but as again, the matrimonial law, according to that, then the survivorship will kick in and it can change situations a little bit.
That's right.
What would you, a typical will, what is being in that piece of document?
Well, usually in the will itself, you will have lists of your assets, of the people who you wish any asset to be delivered to. You will also have you should have what they call an estate trustee, who will be somebody who you trust, somebody who you value. That person is the one who gets to distribute your estate. So you want to make sure you pick an honest person, somebody who would have your best interests at heart, somebody who would want to make sure that whatever your wishes are, they're fulfilled. You may also include adults, if you have small children, of who will be their guardian afterwards, who will look after them. And again, you want to have somebody that is trusted, somebody that you respect, that respects your wishes.
I'll tell you a scenario that happened a while ago with one of my clients. The lady got 6 kids, and she trusted all of them and put all as executor. And you know what happened? At the end of the day, they cannot agree. Nobody could agree
On anything, right?
On anything.
Anytime you're putting multiple parties as executors or estate trustees, there will be cause for tension, and that tension can stop everything. I have one personally now where there is a stepmother, and the biological daughter of this gentleman who passed. They cannot agree on, even though he had a will, he had everything, they cannot agree on how the estate should be distributed. And it's been about 3.5 years where there is a large sum of money sitting in my trust account waiting for a court order.
Wow.
And it just, the legal fees are piling up, and unfortunately not for me, because I'm not actually litigating this, but those funds are with me until somebody decides who they belong to. So it can cause a problem if you pass without a will. And normally what we suggest, and I'm sure Amit, you suggest to your clients, is once you've made your home purchase,
right,
which is often the biggest purchase in anybody's life, you should have a will.
Sit down and finish, get a will done. How expensive?
It's not terrible. For a single individual, you get a will and a power of attorney for about $350. For a married couple, they do them for $500.
Okay.
And that includes 2 power of attorney, 2 wills. The power of attorney you need in the event that sometimes you have an injury where you're incapacitated, but you haven't passed, but you can't go to the bank or go sign papers or whatnot, for which case you need a power of attorney.
Oh, so that's very important. I have a question for you. Are wills something that need to be updated often, or?
Well,
Good question.
it is a good idea to, if you have a will, say for example, that's 20 years old, we all know that things have changed in the world dramatically in the last 20 years with the advent of technology and various things. So it is important to ensure that your will is up to date, and sometimes people's situations change, and sometimes you have selected people to be part of your will that are no longer part of your life. And if you don't change that according to the will, those will be the people who end up handling your estate.
Yeah, for example, let's say we backtrack 15 years ago, you may have, the kids are young, so you may have one of your brother or sister, someone who you feel that will take care of any event we do not come home. And fast forward now, the kids are all adults, you will want to change those things, right?
Absolutely.
Put the kids in place instead, right?
Yeah, absolutely.
So these are we're becoming very, very handy.
Definitely.
That's right.
Right.
And sometimes, when a court is involved in distributing one's assets, these things can take sometimes up to 1-2 years. Sometimes
Could take a while.
It could take a very long while. So we tell people often that for the investment of anywhere from $300 to $500, it is a smart idea to get that will.
To get a will.
Put that in
Absolutely.
place.
What happened if someone get multiple wills? I've seen situations.
really?
Yeah, well, what happened? They didn't remember. They went to one person 10 years ago. They did a will. Then they went and do it with another family member. They did another will, about 2 years before they passed, and then
So which
the
one?
courts
Which
get
one?
involved.
Yeah.
Well, then again, like Jay said, you are in a situation where court could be involved because there may be different things contained in each will. For example, they might say, I want daughter A to be the executor 10 years earlier, and then they say, I want daughter B to be the executor 10 years later.
Right.
And now daughter A says, hey, I was supposed to be the one. And daughter B says, hey, I was supposed to be the one.
So you can get into an argument even before division of assets.
Oh, absolutely.
Yes, I've seen that before. That's an area to be careful. So what would you recommend in situation like that for our audience not to be in that position? So you need to, all the new wills you're doing, you're saying that this person is revoking.
That's correct. Usually you will be keeping a standard line in the will package that states any previous will or codicil that I have drafted is now null and void. This is my will moving forward. But sometimes, you know, unless somebody's doing it with due diligence and good eyes, you can miss such a line, in which case this sort of scenario would arise where you have parties fighting each other.
Right.
Yeah, I've seen it in many situations in these circumstances. What I've seen actually with seniors in my real estate practice, we came across a situation where as someone get older, if the family member is not there too much, they may hire a sitter, and the next thing somehow the entire will is transferred in the sitter's name.
Wow.
Actually, in my career, I've seen about 5 of those.
Oh, wow.
Yeah.
Wow.
Where, you know, all the assets have gone because the guy is not feeling too well, he's on his last lap, and this sitter is there taking care of him day to day, give him all the needs he wants, and suddenly, you know, a new will has been made out.
Wow.
Oh, wow.
How can someone protect themselves in that way?
Well, it's very difficult. You know, you if a family member feels that some fraud has been committed in such a circumstance,
Right.
they should be contacting police.
They can be, that's important. So we will take our break for now. When we come back, we'll talk about what happened with the estate. Last lap. See you soon.
Are you retiring smart? Make your home's equity work for you. With your home's equity in our 30 years of experience, the Retire Smart Properties team can help you achieve the quality of life you've always wanted. Our services are 360 degrees. We'll give you advice, take care of staging and selling, and help you find the perfect home and community to transition to. It's time to enjoy the retirement lifestyle you deserve. Visit our website today to learn how you can use your home to retire comfortably. The Retire Smart Properties team, powered by RE/MAX West.
Discover the incredible India.
Hello everyone, and welcome back. Now we will actually be talking about the procedures of an estate sale. Also, I'd like a quick reminder, I'd like you guys to like and share this video. You can also check us out on mytcnnetwork.com. And also, if you have any questions, you can reach out to us right now, live for the next 12 or 13 minutes at 647-931-4701. All right, so let's jump right into it. Estate sales, Manbir.
Estate sales, much of what we've just discussed in our previous segment, estate sales also involve this issue of ownership of a property. 3 ways to own a property: as a sole owner, as a joint tenant, or as a tenant in common.
Right.
Could you break down on those for our audience, please?
Absolutely. A sole owner will be the simplest and most easy to understand, which is that if you are entitled to a property alone, you are the sole owner. If Jay owns his house, Jay owns his house. Manbir
Right.
cannot come and say, Jay, I own a piece of your house.
Right.
Right. But if Manbir and Amit own the house together, for
Right.
example, if we buy a property as an investment,
Right.
and the property, for argument's sake, is $100,000. Amit put in $60,000. Manbir put in $40,000.
Right.
We may decide that the fairest way to divide this property is 60-40 relative to
Right.
our share.
Right.
Okay. In which case, we would take title as tenants in common. So Amit would have a 60% share in the property, and Manbir would have a 40% share in the property. If something, God forbid, happened to either one of us, then Amit's share would come back to his estate in that same 60% figure, in case the property had, say, increased in value to 200,000. Amit would get 60% of that 200,000, well, his estate, and if it was my estate would get 40% of that. I would not automatically be able to take over Amit's portion just because I was the other person on title. But the third manner, which is the joint tenancy, if Amit and I took the property as joint tenants, then irrespective of his 60% and irrespective of my 40%, even though that might be the financial contributions we have made, the property will go automatically to the surviving sole owner. So if something happens to me, Amit would be the one who gets to take over the property.
And that's in joint tenancy when you tie the knot, right?
When you tie the knot.
You tie the knot, you tie the knot.
That's right.
When you say I do, I do.
You do.
That's about that.
That's for sure.
that's the difference between, right?
We all have said I do.
Right. Now let's talk about the process involved. So the person did not come home. They got the will. What happened after that? Can I just go and sell the property immediately? Do I need to do anything?
You do still need to probate the will.
What probate means?
It's essentially the process by which you are going to go to a court and get a judge's order that says your estate trustee has the ability to sell this property. And then the estate trustee has to account for the sale to the estate. So there could be 4 or 5 different people who had a share in various amounts of money. The estate trustee would be responsible to complete the sale and then divide the proceeds according to whatever the will was. You have to do different than a regular sale and purchase transaction. You have to do what is called a transfer by personal representative. So the property gets transferred first from the deceased party,
right,
to the estate trustee,
right,
and then from the estate trustee to the new home owner. Okay. So there's a middle step that's involved that is not present when it's just a straight sale from party to party.
Right.
And you have to register that so that the buying party and the city is aware that the real homeowner passed. We're doing this sale by way of an estate, and then that's the process.
What cost is involved?
In probating a will, it just depends on what is required, but usually I think most lawyers, they're anywhere from $1,500 to $2,000.
Right. That's the lawyer, but now the government. I mean, many times lawyers will call and say, hey, you know what? I need you to do a market evaluation of this property. We want to know the value so that we can get the will probated.
And that'll do. So that can vary.
Right.
The estate tax can vary.
Yes.
Depending on what is in the state, what is in the value of the state.
Do they consider the real estate portion alone to be taxed, or all the other things?
Everything.
So the car and the house and
that's right.
And everything will be so the government even get you after that.
But they don't leave you. After that. But if on a principal residence and a singular residence, the government does not tax that. So if it's your own home that you lived in, you pass, you won't pay an estate tax on that property.
I see.
But if you have multiple properties, then you
and that's exactly what I was going to ask. Many of our clients are investors and have 1, 2, or 3 properties, for example. So can you outline some of the the pros and cons and really how to deal with that and how to navigate that?
Yeah, and the cost also involved. Let's talk about the cost, and then we can do the pros and cons.
Yeah, well, I mean, the cost again, if you have
multiple
properties and you have a sizable estate, you will pay an estate tax. It will be a fair penny,
about 5%,
give or take, depending on the scenario.
Close to 5%.
Giving in the scenario, which is why oftentimes when you're buying investment properties, a lot of people, they will put on a child on title, or they'll put a spouse on title, or they'll put somebody on title that you would in any event give this asset to. So that way you kind of circumvent
You can.
Well, you can circumvent the immediate paying of the tax.
In that case, could you have many joint tenancy? For example, okay, this property I'll make a joint between my
Yeah.
big boy. That property I'll make a joint between my
Absolutely,
daughter.
sure you can.
And that way, upon that, it just automatically
Sure
right to
you can.
survivalship.
Absolutely, absolutely, you
So
can.
that's-
And oftentimes people do
People
that.
do
That's-
do
that's
that.
right.
Many joint tenancies.
That's right.
It helps in that way.
And it's important to do in that way too.
Right.
So when you say you're circumventing the immediate paying of taxes, is that just you're circumventing it for a short period of time, or does that go right over to the joint tenants?
Well, no, in that case, the property would revert straight to the joint tenant. If the joint tenant is a surviving individual, they will not be paying.
So it's a
Right.
great strategy. So that's
No,
yeah.
but you got to look at the other side of the coin. You can say 10 years or 15 years down the road, I'll add my son on a joint tenant. There will be some income tax violation. If you
right.
do that, you have to actually, I think you do have to say, hey, you know what, person is coming on. This is what's happening and everything else.
Okay.
All right, that's a good question for one of our next topic in income tax.
Yeah, definitely.
Absolutely.
Yeah, because
And a lot of and this is the thing, that a lot of these, once you're into an estate sale, these questions and topics spill over into other areas of law and other expertise that people need to be aware of, and it's probably something that you could address in another show.
yeah, definitely. That's an important area. So now the property goes up for sale, estate sale. What's the time frame it may take, Manbir, from, let's say, debt until you
I think
have probate and
Typically,
everything else?
my understanding is typically probating a will, depending on which jurisdiction you're in. If you're in a very busy jurisdiction, for example, Toronto, I think might take about 60 days, 45 to 60 days. And some smaller areas may take 25 to 30 days, because at the end of the day, it's still a court process. You have to get your order before a judge. You have to get it signed off on. And this, to get that order, usually I would say 45 to 60 days, in which case you get your order for the estate trustee to be able to sell the home, and you're okay.
Okay, so it's always a good practice as well for people to put away money, family members to put away money for this situation, especially if the family have multiple assets.
Well, yeah, I mean, and just it's similar to putting away money for a funeral.
Right.
Yeah.
And nobody wants to do that. I mean, this is part of
You
life
got
that
You
we
got to do that because the government
right.
want their money up front before you sell the
That's
estate,
right.
right?
Yeah,
Let's say someone estate is about
government-
$5 million. It's gonna add up at
government
5%.
government is going to get paid.
All right, that's why many people take out that little life insurance that says
That's right.
one day I'll get that money to
All right.
cover to pay the government so
Yeah.
that I could get all the other assets free up, right?
Absolutely.
Yeah.
Absolutely.
I've seen situations where they're strapped.
And
Because-
Assets are tied up.
and that often happens, and you're in a scenario like I discussed with my clients, who are waiting 2 or 3 years, and you may in there have a children or somebody else who's supposed to benefit from this, who does not now get what was to be theirs because of tax that couldn't be paid, or probate that couldn't be done, or anything of that sort.
Right.
Yeah.
And what happened if after a while, I'm sure you saw this many times, the funds remain in your trust fund all the time? What's happened with that money?
Well, I mean, eventually that money must leave your trust account. It cannot stay. If it is there for a dormant for more than 1 year, then you have to inform the Law Society, and you have to then either turn the money over to the Law Foundation of
Okay.
Ontario,
Okay.
or you have to, in some fashion, disperse or make some movement with the money. So usually, if we have any trust account monies that are left for longer than 1 year, you're under obligation to inform the Law Society. and
Okay,
tell
so
them.
it's
Right.
so that's really trust money, and
That's right.
So eventually, that money goes to the government if they can't come to anything, right?
That's one way of looking at it.
Right, so
That's one way of looking at it.
That's the way it is.
Yes.
Okay, that's very good. Manbir, it's been a real pleasure having you today. It's lots of information within this hour that people can make use of. I will encourage everyone to please share again this information. And if you have any question for Manbir, give your information again, please.
It's Manbir Sodhi, and I am located in downtown Brampton, 905-457-2546. 905-457-2546. Thank you guys for having me here today.
All
A
right,
real
great.
pleasure, and see you next week.
Take care.
Take care.
Think you have what it takes to bring value to the community? The TCN TV network is expanding and now accepting TV show proposals. Here's an opportunity to build celebrity status and become part of an elite group of community advocates that are focused on building, strengthening, and empowering our community in a positive way. Are you interested in embarking on a new adventure? TCN TV is searching for people interested in opportunities to change the conversation and pave an unforgettable legacy. If you feel you have something of value to offer, send a written show proposal to shows@mytcntv.com.